katoa.
Simon Bridges.
Speaker, every defendant in the summary jurisdiction and every accused in the indictable jurisdiction have the absolute right to counsel, and as I'm about to say, competent counsel, and counsel who know that the system's not for them but for the players, the defendants, the accused, victims in the system. But I want to say firstly to Hone Harawira, who's inclined not to necessarily support this bill, that actually if this bill is for anyone, it's for those Māori he was talking about, who at the moment, yes, do go to prison in disproportionate numbers, but who have the most to gain of anyone of having competent counsel in the courts in this country. So this bill is very important. As I say, everyone has a right to counsel, but they need to be competent. And I'm the first to accept that the vast majority of criminal lawyers in this country are, but there are some, they've been referred to, I think, car boot lawyers and various other sorts, who aren't competent, who actually, and I've seen them, and I'm not going to name them, they may vote for me, but I want to say who actually have had a law degree for 30 years and haven't been on a refresher course with the Law Society for 30 years. There's this perception out there somehow that criminal law is easy. Actually, it's one of the most difficult areas of law, in my opinion, to practice in. It's an area, if we go on what we pass in this House, year after year, actually probably be about 12, 13 statutes that have made wide-ranging changes to the arena of criminal law. Those things need to be kept up with. They're not simple, and actually if anyone needs to be on top of their game in the practice of law, it's criminal advocates who have literally people's lives on the line, and as we do, and I think it's right, put up the penalties with bills like our three strikes legislation, the stakes increase. David Garrett had something to do with it, but I'm not sure what. The other thing that, of course, is important when you're talking about counsel is a system that's not just for their benefit, but is actually for the benefit, as I say, of the real players in it, the victims and the accused. And yes, there has been gaming in our criminal justice system. Very briefly, Dame Margaret Baisley talked about delaying of pleas to maximise legal aid. I've certainly seen that, where guilty pleas are put on the morning of trial. It's been quite clear that the pleas were coming for a long time, but by doing that, defence counsel are able to claim maximum preparation for the trial as well as obtain the guilty plea. Top-up payments, retainers from clients, despite getting their legal aid, all they're legally entitled to, asking for more from the client. That's a despicable practice, but Dame Margaret Baisley found evidence of that. And those who come along ill-prepared for cases, certainly I have seen and I'm aware of defence counsel, again very much in the minority, who but the first they learn of a case in a jury trial, so where the stakes are high, is what they pick up from Crown Counsel when they open the case for the Crown. That's not good enough. Actually, this bill addresses those concerns, will do something very real about it with the various new agencies, tribunals that it creates to ensure that there are higher standards, and I commend this bill at first reading to the House.
Well said. Well spoken.